We are hoping to keep time, so welcome everybody to this session on why does international arbitration matter in New Zealand. And before I introduce our two speakers, who are well known to you, I'd just like to say that this topic would have not been featuring in an AMIN's conference even 5 years ago, certainly not 10 years ago, and such a paper would, if were presented there, be regarded as unusual and of academic interest only. But I don't think that's the case now, and international arbitration, we hope, is becoming more and more important in New Zealand, and our speakers will tell you why. Why has it become more important? I think there are several factors. The first is New Zealand adopting the arbitral model law in 1996, which was a very big step forward, which brought us into the international arbitration community, because so many countries have the model law. I think the total is about 70 now, and I'm asked to check. I haven't checked recently. And others, like the UK, have systems of considerable similarity to the model law. And people know what it means when you say you're a model law country. Secondly, in 1999, ICC New Zealand was born, and New Zealand hooked up at last, some 65 years after it was formed, with the ICC, International Chamber of Commerce, Court of Arbitration, centred in Paris, now with a branch office in Hong Kong and a centre in Singapore. So that was important because it meant that a New Zealand representative would sit on the governing body of the court as country representative, which means if you're there checking through all the awards before they're issued, and also has a member on the International Commission of Arbitration, which was responsible for the latest ICC rules, which came into force early this year, which the product of a huge process of consultation, though some might say that there are aspects of it which have the hallmarks of having been prepared by a committee. And the third feature was that the gradual appointment since 1999 of various international arbitrators from New Zealand, form of invisible export, if you like. But not only has the ICC done this, but the Permanent Court of Arbitration in The Hague and ICC, which you'll hear more of later, in Washington. This charge was led by David Williams, who has a large number of appointments and is regarded as one of the leading international arbitrators in the world, and he has done huge amounts to bring New Zealand to international notice, so that they can see that we're a small and unthreatening country which has something to offer in the way of competent, incorruptible, efficient arbitrators. My two presenters today are Professor Campbell McLachlan on my left, who is Professor of Law at Victoria University, a successful author and a scholar of international repute in the field of arbitration. He's had practical experience with the large arbitration-based firm of Herbert Smith in London, and he has received a number of arbitral appointments, notably from ICC and also from other arbitration centres around the Pacific Rim. On my right is Daniel Kalderimis, partner of Chapman & Tripp, one of the joint authors of Williams and Carferu, which I gather wasn't there, but was received a sort of papal blessing from the Attorney General, and he has recently been counsel in an international arbitration held in New Zealand which had absolutely nothing to do with New Zealand, except that New Zealand was the venue for the hearing, and he appeared as counsel in that. He has had overseas experience and having been in the London arbitration firm of Freshfields, I can't remember the rest of the bookhouse, something or other, he'll tell you. And he has also written quite a bit on international arbitration. The way we're going to run this is that I shall introduce a number of questions and then invite one or other of the presenters to perhaps speak not at length, but speak to it first, and then perhaps for the other to contribute, and then perhaps if there's anything from the floor, we might take it. But time is very limited, and we've had such a wonderful example of keeping to time set by Mr. Davidson that I wouldn't dare infringe the strictures. So the first question is, why does international commercial arbitration matter in New Zealand? Campbell.
Well, thank you very much, Sir Ian, for that kind, indeed overly generous introduction. The central point that I want to put before you in answer to this first question, why does international commercial arbitration matter, is the notion that we've been accustomed to thinking about arbitration essentially as a process of dispute settlement, as a process which is in some way alternative to a legal system. But actually, if we look at what's happened to international commercial arbitration over the last 50 years, which is really the period of its great flowering, what we see, or what I want to suggest to you we see, is a development from it being simply an alternative process to being, in some senses, a system in its own right. And really, what I suggest is that the last 50 years have really been devoted to unshackling international commercial arbitration as a process from the control of national legal systems, not as Professor Michael Wiesman once described it as some kind of anarcho-capitalist fantasy, but simply so as to provide a neutral, flexible and, most importantly, enforceable means of dispute settlement when commercial parties come from different countries and thus different legal systems. And that idea, which would have seemed totally revolutionary 50 years ago, has now almost become an orthodoxy, so much so that the Supreme Court of Canada, as recently as 2007, was prepared to say arbitration is part of no state's judicial system. The arbitrator has no allegiance or connection to any single country. In short, arbitration is a creature that owes its existence to the will of the parties alone. Now, of course, I'm not saying that arbitration's got nothing to do with national legal systems at all. Of course, it vitally depends upon national legal systems for support, both to facilitate the process and also ultimately to enforce awards at the end of the day. But nevertheless, the proposition that I want to put to you is that why we should be concerned about international commercial arbitration in New Zealand is that we need to start thinking about the system, which we've now opted into as a result of having become, as Sir Ian says, a model law state. We need to start thinking about it as a system in its own right, and Daniel will explore some of the implications of that for practice in a moment. So why do I say it's become a system? Well, simply because, as a matter of factual observation, arbitration has today become the dominant form of resolution of many types of international disputes. So it's shifted from being the exception, the thing you do if you decide to opt out, to the rule. And that's, in doing so, it's taken that core idea of consent on which all arbitration is based from the basic notion of a contractual consent to lots of examples of what I would call standing consent. So consent given to arbitration, standing arbitration of investment disputes by treaty. In sports law, one often finds that a condition of participation in any sporting endeavour is standing consent to arbitration. So the notion of consent has been much expanded from the original contractual notion. Second reason why I say we should start thinking about this as a system is the sort of semi-constitutional status of the New York Convention and the convergence on common standards of arbitration, which has been driven in large measure by the UN Commission on International Trade Law, which is why it's so good that we've got with us for this conference the head of the Asia Pacific region of that commission. So what that's given us is a common basis of rules from which we can begin to develop what has been called a common corpus of international arbitration law. Now my point here though is we shouldn't accept this notion that arbitration is some self-standing legal system without wholly uncritically. Because if you want to make a claim, as many international arbitration practitioners do, that this is some kind of separate self-contained system, you need then to accept that arbitration can be judged by the same kind of standards that other legal systems can be judged. And of course, if we start to measure arbitration against the sort of rule of law standards we would expect of a national legal system, we immediately encounter the observation that there are a number of issues. After all, many arbitration awards, the majority of arbitration awards are not public, so the basic notion some of the most basic notions of transparency don't apply in arbitration. In fact, it's the very reason why many parties in commercial disputes go to arbitration, is so that their awards are not made public. But the implication of that is that developing the law through arbitration, through the system of precedent which we're used to in national legal systems, is much more difficult. It also means that we need to pay much greater attention to some of the ethical issues that arise in the context of arbitration, in particular in terms of independence of appointments. So I think as it's begun to mature, international commercial arbitration as a system has begun to feel some of the pressures of being judged as a system. And we should also recognise that there are some inherent limitations in the notion of thinking about arbitration, international arbitration as a system. As I've said, in the end it all depends upon states being prepared to play ball, both by supporting the system, by not unduly intervening in it, and also ultimately by enforcing awards. So I think, in conclusion on this very first question, why should we care about international commercial arbitration? I think we're at something of a crossroads in terms of the development of it as a system, and there are a number of different ways in which it could go. It's possible to see that arbitration might become increasingly more specialised and fragmented, so you get people who are just specialised in doing sports arbitration or construction arbitration or whatever. It's possible in some fields that we could actually see a movement towards international judicialisation. After all, that's what happened to trade law, isn't it? We had an essentially arbitration model for nearly 50 years with under the GATT, and then at the time of the Marrakech Accords, there was a conscious move towards a more judicial model for WTO disputes. And there is an active debate in some fields at the moment about the need to develop appellate mechanisms for international arbitration. I was interested to hear a flavour of that in the fireside chat which preceded this session. But I think the third, and perhaps for me the more optimistic future, is one potentially of convergence, so that arbitration would retain some kind of, international arbitration would retain some kind of coherence as a whole by converging on general principles which underpin the system as a whole, and which would both, is in a sense, both the promise and also the responsibility, the increased responsibility which arbitration has, as it's now shouldering a much greater range of a number of disputes than it previously would. So I think with those comments, I'll pause at this point.
Perhaps Daniel would like to comment.
Well, I think there are a number of different themes in there, and they intersect with a number of things that I was going to try and develop, or am going to try and develop. I think the three things that arise out of that, to me, and they're all high-level things, they're all self-evident in a way, but I think their implications are important, are these. One, the driver of arbitration, or international arbitration, has been globalisation. It is the system that has evolved to meet what has been perceived to be the need of some system to resolve business disputes. And it is the system that resolves globalised business disputes in the globalised world we live in. And that's partly what Campbell is picking up. That's the driver. I think the effect of it has been that we now have privatisation of commercial dispute resolution in the last 20, 30 years to a level that we haven't seen before. And I think there's still some coming to grips with what that might mean that I want to touch on. And then thirdly, the means by which that system works has given rise to a distinctive process which is still evolving. And the last session, talking about how costs might be allocated in arbitration, is one of those many nexuses that you can find of how we try and relate that distinctive process to things that we might be more familiar with. So I just wanted to briefly try and develop those thoughts. I think the globalisation point is in a way the easiest. If you ask why has international commercial arbitration become the most used form of dispute resolution for international disputes, there are two main advantages that it has that nothing else has. One is it gives you, by definition, a neutral forum for resolving your dispute that's not either court of either one of the parties. And in relation to that, it actually allows you to choose who your judges are that give you an additional sense that you're not being discriminated against by the formulation of the panel that you get. But secondly, the New York Convention, as Campbell's mentioned, has been an immensely important document in making sure that arbitration has supplanted transnational litigation for resolving disputes. The fact that the award you get from an international arbitration is more enforceable than a court judgment means that you have to have a very good reason not to go with that process. So that's the easy thing. It is the system that was most nimble, that was most adaptable, that when international commerce started picking up at a certain pace, was able to evolve and meet the needs of business. Slightly more tricky, I think, is the question of what it means to have such a successful dispute resolution method which is privatised. Now, Campbell's quite right. It's only privatised because the courts and states have allowed it to be so. Arbitration doesn't work without the implicit backing of court sanctions to make it work. And so therefore it is a private space for resolving disputes that has been created by courts allowing that private space to happen. So every time a court upholds an arbitration award, refuses to entertain an appeal, grants an interim order to allow an arbitration to happen, all of that is effectively ceding some state power to resolve commercial disputes and allowing those commercial disputes to be resolved in a private space. And I think it pays to reflect a little on the implication of this, because if you think about privatisation in all of the other spheres in which it happens, it's a controversial topic, and it's controversial for good reasons. I was reading The Guardian the other day, and controversially, The Guardian's education reporter wrote a mea culpa column in which she revealed that she sent her child to a private school rather than public school. And for Guardian readers, that was read rag to a bull. 500 online comments went up within an hour, and a famous author was commissioned to write a response column. And what she said at the end of her column was this: I plan to send Katie to a state secondary school if I can, but if I find myself dissatisfied with what's on offer, I'll go private again. Until local schools meet families' needs and cater for each individual child, can you blame people for putting their hand in their pocket? And that's basically what I hear my clients as businesses say. They'll choose the system that they think caters best for their needs. And so we're now in a world where it's not true to say, when you talk about justice and how it's being developed and how it's being handed out, you just talk about the state apparatus. We actually have a world in which, like healthcare, you can go to the public hospital and get certain operations, or you can go private and get other operations. Healthcare can be distributed through these two means. So now can dispute resolution. There's a New Zealand Justice Forum that was set up about a year ago to try and look at problems about how justice is delivered in New Zealand. But it's modelled on the old lines of basically trying to work out how the High Court can better meet the needs of users of the civil justice system. I think international arbitration has changed that game. The question is not how the High Court can meet the needs of civil justice users. The question is how available services out there, whether they're public or private, can meet those needs. And a major available service is international arbitration. So I suppose my point on this privatisation effect is that we are never going to be in a space again where we can talk of a monolithic state justice system. There is now always, I think, going to be a form of international, commercial, private dispute resolution through arbitration and international, commercial, public dispute resolution through transnational litigation. And it will wax and wane at different periods and different eras how far the courts support that private space and how far they don't. But it's here to stay, and it's a part of the equation, and I think there are big implications of that. One of my tasks as I prepared for this was to reread the book that many of you have probably already read, Dealing in Virtue, the famous 1996 sociological study of how international arbitration developed. And it's a brilliant work because it's not written by the cheerleaders. It's not written by the people who tell you international arbitration is the best thing since sliced bread. It's written by some quite brilliant and disinterested sociologists who are able to see the power relations that led to arbitration happening. And they make lots of points, including that there was a major culture clash in the 70s and 80s as to what arbitration actually was. There were the grand old aristocratic European academic professors who had a certain vision, and then there were the white shoe New York litigators who had a quite different vision. And there's a very telling anecdote on one of the pages where one of these white shoe New York litigators is giving an interview to the sociologist, and he says, "We were having this arbitration, and I realised I got it totally wrong, because I had arranged for this very expensive transcript to be produced at the end of every day, and I produced it at the end of every day, and I handed it to the tribunal. On the last day, I had to apologise to the chairman because the transcript wasn't going to be available. So I made that apology. And the chairman turned around and said, "Don't know why you're telling me that. I never read the transcript. I thought you produced that for yourself." And what that tells you is that there was a different view. The New Yorker was focused on the facts. He was a forensic man. He was trying to win the case by cross-examination. The academic arbitrator was focused on the law. And what people said in response to cruel cross-examination questions was entertaining, but not really decisive, and he didn't need to sit down and read it. The process has converged a lot from that point, and that's really the subject of the next question. So I'll pause before I get into that. But what I wanted to sort of emphasize out of this is that the privatization that's happened has come about through different people in different positions of being able to control this private network of dispute resolution. And over time, they've reached forms of compromises that allow a form of practice to evolve. And that form of practice, not always very clearly written down or accessible, is as much a part of this beast as are the formal instruments like the New York Convention and the model law.
Thank you, Daniel. Well, just a point that occurred to me is that one reason why, for example, parties would want to specify international arbitration in their contracts, particularly when they're from different countries, would be that the courts of some countries, you wouldn't want to go there. I don't think, hopefully that doesn't apply to New Zealand or Australia, but one can think of places where either because of the huge delays or because of the sort of endemic corruption that you just wouldn't want to go there, and arbitration provides a better alternative. Would that be right?
Yeah, certainly there are a number of countries where you would want to litigate in the courts.
Now, you would like you now to perhaps expand a bit on the topic, but in particular, when it is properly understood and applied, international arbitration can provide a specialised means of determination which gets to the heart of the matter, but without a lot of the procedural performance that goes on in ordinary litigation in the courts. Comment on that?
Yes, this really sort of brings the discussion around to sort of, so what? Why does any of this matter in New Zealand? And I thought the way to try and articulate this was to mention that there's been an update to this study here in the recent edition of Arbitration International, where a couple of academics did a survey of what people look for in arbitrators, and they suggest that the two types of arbitrators who were identified in the Dealing in Virtue book being, on the one hand, the so-called grand old men, because they were all men in those days, and on the other hand, the technocrats who were real sort of arbitration specialists. The postulation is there's a third generation that's emerging, which are basically professional case managers. The key skill they have isn't knowledge of substantive law. While they do have to know something about arbitration process, that's necessary but not sufficient. What really gets people appointed to international commercial arbitration are their skills in case management. What I wanted to do was to just try and say a couple of words about what the case management part of arbitration means for New Zealand. And the argument goes like this. Firstly, the sort of case management practices that are in vogue now are different than the ones that were in vogue 10, 15 years ago, and I expect the ones that will be in vogue in 10 years' time will be different again. And that's because these practices aren't set out in the relevant instruments. Each instrument, rather like a donut with a big hole in the middle, leaves an awful lot of space for arbitrators to decide what procedure they want to adopt. And when New Zealand in 1991 wrote a report, in fact I think I saw Sir Kenneth here before, yes, there he is. It might have been Sir Kenneth that wrote this, but this was on what we do about this very broad procedural discretion in Article 19.2 of the model law, which we enacted in our first schedule. The text of the report said, the succinctness of Article 19.2 may trouble lawyers and others used to more detailed procedural codes. For that reason, for the avoidance of doubt, we propose that the detailed provisions appear in Schedule 2. Now, Schedule 2, New Zealand lawyers will know, are the optional opt-in rules that you can use for an international arbitration in New Zealand, or the optional opt-out rules that you can use for a domestic arbitration in New Zealand. But it's not really true to say that they contain detailed procedural rules in any way equivalent to what we find in the High Court rules. In Clause 3, they basically contain rather a laundry list that tells you of certain things that an arbitrator may do. They may order interrogatories. They may require parties to discover documents. They may adopt inquisitorial processes. But how, or on what basis, remains unclear. And so this gets you into the hole in the donut. And that hole's matters which would have been filled by detailed procedural rules in the domestic court are actually filled in arbitration by less formal rules, either by habits and understandings, you just know how an arbitrator likes to do things or how other counsel are going to do things, to customs, such as the use of a Redfern schedule, to soft law, like the IBA rules on the taking of evidence that Professor Garrow is going to be talking about this afternoon. And the thing is, New Zealand has now crossed that Rubicon for its domestic arbitrations. So it could have been the case that we adopted rules for arbitrations that didn't have anything to do with how you run an international arbitration. But we didn't do that. We adopted the model law with a few bells and whistles that were designed to meet New Zealand circumstances. But basically, we're a model law jurisdiction, and the model law exemplifies the hole in the donut approach. It doesn't tell you what procedure you're going to use. So if you want to run any sort of arbitration in New Zealand, you have to face the existential vacuum right in the middle of it as to how it's going to be run, what procedures are going to be used. We heard about costs before, how costs are going to be decided. How is anything going to be done becomes a question up for debate. And I can tell you as counsel in arbitration, it basically creates a meta level of dispute for everything if you don't manage to agree these things at the start. Instead of just making an application that interrogatories be administered, you have to make an application that interrogatories be administered, and that the very concept of interrogatories is a good idea and one that ought to apply in this arbitration. You have to argue not only for what you want, but for the power and the discretion and the point of using the procedure that you actually want applied in your favour. Now, the short answer to all of this, the question that Serene asked me that I've come to in a roundabout way, is that arbitration is efficient and useful and practical where parties anticipate the hole in the donut and agree in advance to a procedural order or have shared practices that allow them to navigate this without the hole just getting bigger and bigger and bigger. But it really doesn't work if you don't anticipate that hole in the donut, and every time something comes up, you have to have a meta debate as to what process you're going to use to resolve it.
Thank you, David. The question of New Zealand signing up to a treaty which would allow disgruntled investors to sue the New Zealand government has been in the news lately, and a group of legal people of various hues has signed an open letter or something to somebody. But it does bring into focus the question of international commercial arbitration against states. And Campbell, I'd like you to comment on implications for public law disputes.
Well, thanks, Serene. So we're shifting the focus here from the pure commercial dispute, we've got a commercial party on both sides, to the notion of a claim brought by a commercial party against a sovereign state. Now, of course, there's nothing new in the notion that we might use arbitration to pursue claims for expropriation, denial of justice and the like in order to protect or to vindicate the property of aliens. What's new-ish, and certainly very new as an idea in New Zealand, is that there might be a direct right of arbitration which the commercial party itself could invoke as opposed to its home state bringing the claim on the level of public international law. We were an early participant in the ICSID Convention, the main international treaty that provides a means of dispute settlement in this field, which was framed in 1965. We've had one reported case which dealt with a claim by Mobil Oil in relation to oil in the Taranaki oil fields, but we have not had extensive experience, as the rest of the world is now beginning to do, in the pursuit of claims which are founded on bilateral investment treaties. Those claims as a whole are new. I mean, the first one only arose in the 1980s, but there has now been a rather significant number of claims affecting many regions in the world, including the Asia-Pacific region. So in New Zealand, we haven't been an active engager in investment treaties. That one can speculate as to why that may be so. It may be because we've seen ourselves traditionally as more of a capital importing rather than capital exporting nation, and in any event, of course, we have, and if we want external proof of this, one can look at the World Bank's Rule of Law and Governance survey. We have an excellent and robust legal and judicial system. So the argument that we needed to provide such treaties in order to assure investors that they would receive an appropriate level of redress if they ran into difficulties was not perceived as a major brake on investment. The big shift for us, of course, was the China-New Zealand FTA, which for the first time included, or the first major example of including such a provision. And there, of course, as you can imagine, the equation may have come out somewhat differently, the actual equation in terms of where the rights and liabilities might fall. And that issue, as Serene says, is now taking centre stage with the pending negotiation of the Trans-Pacific Partnership Agreement, which is no longer simply, as it was originally envisaged, an essentially South-South Pacific agreement, but with the participation of the United States. It's taken on a very different hue. But what I want to say about investment treaty arbitration is essentially just three very short points. The first is it's a hybrid. It inevitably involves a mix of both private commercial and public law issues. That's what it's about. It's about protecting commercial parties from alleged abuses of state power. And it's there as an attempt to try to depoliticise those disputes by taking them out of the public arena and placing them in what is set up to be an independent arbitral forum. But of course, at the same time, what those disputes also are about is actually trying to find an adequate means to take account of legitimate state interests in protecting public regulation. So what the arbitral function in investment treaty arbitration is a very different function from that which applies when both parties are commercial disputes. I have to say, in my experience in sitting on these tribunals with arbitrators from all over the world, this is an exercise which is taken highly conscientiously by those who are appointed to those tribunals. But my point here is it's of vital importance that you equip those arbitrators with the right legal framework to decide the dispute. Arbitrators are bound to apply the law, as arbitrators are in any dispute. And for the most part, the law in an investment treaty arbitration is described by the treaty that the states have entered into. The arbitrators are bound to apply that. And so getting the language of those treaties right is of vital importance. There is a reason, I think, why almost all investment treaties in the world today are bilateral. The reason is that what a bilateral negotiation enables the two states to do is to make a dispassionate assessment of where their respective economic and political interests actually lie, and to strike a bargain accordingly. When you try to do that on a more multilateral basis, as is the case in the Trans-Pacific Partnership draft agreement, it becomes much more complicated because you're trying to balance a whole bunch of trading relationships, each of which may sit in very different positions to each other. You know, our trading relationship with Vietnam, a very different animal to our trading relationship with the United States. And it's become particularly complicated in the context of the Trans-Pacific Partnership in view of the Government of Australia's publicly announced policy not to engage in investor-state arbitration at all. Of course, our most major free trade agreement is the CER with Australia, and so we face a position whereby our closest trading partner would not engage in such a system, and yet we are still proposing to do so. So I think the final and important point is that it's therefore particularly important that we make sure we have a proper debate in New Zealand about the balance which we want such an agreement to reflect. It's particularly important because of the implications that that balance will have for the extent of public regulatory power over the economy and the control of the economy in New Zealand, which at the moment, of course, is regulated at the admission stage by the Overseas Investment Act, but at least under the drafts which have been circulated on the internet, and one doesn't know whether those are the current drafts, but nevertheless, that's all we have to work with. The currently proposed draft would apply to the admission stage as well. In other words, it would effectively preclude each state from having the opportunity to decide at admission stage whether it wishes to accept a particular investment or not. That seems to me is an important policy issue which has to be brought out and analysed and discussed in a balanced way within New Zealand and indeed with the other negotiating states before such a vital step is taken.
Thank you, Campbell. Well, I think the final topic, which we just have time for, I mentioned earlier about New Zealand providing arbitrators who are seen as neutral and of some quality with integrity. And the final question is, can New Zealand export its legal expertise into this international commercial arbitration process? Can we?
Well, my answer is yes. And essentially the point of adding this final comment to our deliberations this morning is really to act as a note of encouragement. I mean, my personal experience has been that there is a very significant demand, particularly in the Asia-Pacific region, for the very things which the New Zealand legal profession and New Zealand qualified arbitrators have to offer, namely a high level of legal expertise and incorruptibility and independence. Those are the factors which one wishes to have in international arbitration. And also, just picking up on Daniel's point, a healthy measure of common sense in the effective management the arbitral dispute. I do think we have an opportunity here that there is a constantly rising number of disputes, commercial and investment, being determined by arbitration in the Asia-Pacific region. It is actually, as a region, relatively under-lawyered, but now we have seen the emergence of important arbitration centres in Singapore, in Kuala Lumpur, in Mauritius, to name about three, which, comparatively speaking, are on our doorstep. They're certainly a lot closer to us than London and Washington, and they're closer to us than they are to those practitioners in London and Washington who will otherwise service those disputes if we choose not to. So I do think there's an opportunity here if we go out for us as a specialist arbitrators in this country to go out and provide that service, not simply to New Zealand clients, but also potentially to clients or parties wishing to make appointments in other countries in the region. Thank you.
Thank you. Well, we have 5 minutes for any questions from the floor or comments. Please make it brief. Yes.
It's more of a comment. The last point about can New Zealand export its legal expertise into the ICA process. I think we can do that not just as arbitrators but also as counsel, given the rise of international communications. I mean, I sit in Tauranga, and most of my work is international commercial arbitration. Most of my clients seem to be Russian for some reason, largely because they don't trust their own courts. It's all under English law. They simply don't care where I am in the world as long as I can turn up for the actual hearing. They would rather not have me fly around on their dime, going to meetings I don't need to go to.
I'd like to make a quick comment in response to that. I think it sort of picks up on what Campbell was saying as well. I think that if you imagine that the three big themes here are globalisation, privatisation, and how we're going to sort of negotiate something like the TPP and affecting our state sovereignty, etc. You can choose to look at all of these things in a victim mentality, that these are just things that are happening to us. We just need to accept that New Zealand will be more marginalised, there'll be fewer opportunities, and we'll just get sued by a whole lot of Americans. Or you can see it as an opportunity. The world we're in has a huge amount of opportunities to use globalisation and privatisation to be able to do things that we couldn't do from New Zealand previously. Like everything in New Zealand, it's always harder because of the tyranny of distance and because we're a small economy. But it doesn't mean it's impossible. It just means we need to try that bit harder.
On that point, Daniel, is arbitral immunity under threat in the international arbitrations you're talking about, in treaty arbitrations?
By arbitral immunity, you mean immunity of arbitrators?
Yes.
I think our chairman might want to comment on that point.
Yes.
Well, I mean, every agreement would have arbitral immunity written into it, and I think it's in the BITs, isn't it?
Yeah, I mean, it is a basic principle of the exit convention as well. That doesn't mean, however, that if you read the republished awards, that arbitrators have found themselves wholly immune from various sorts of actions taken by disgruntled parties, often in their own courts. I don't think the principle is under threat, but its observance is sometimes challenged. So one can't say it's a completely risk-free business.
We have time, I think, for one more question. Well, if there are no more questions, it falls to me to thank both our presenters for a very educational and instructive presentation to us today. I hope you know a bit more about international arbitration. I hope that should opportunity come your way, you take it, because I think the more people that get involved, the more New Zealand presence will be appreciated, because, as Campbell says, I think we are able to deliver a pretty good product with the Kiwi get on with it attitude, which sometimes some international arbitrators have specified nationalities do take an awful long time to do very little. And I think we are used to getting on with it, and also we have the virtues of neutrality and integrity and, I think, ability. So thank you all very much. Thank the presenters, and thank you all for coming.